Are you being denied time with your child in Wisconsin? Most parents think that endless police reports are their only option, but that approach could actually do more harm than good. In this video, I will cover the 2 power moves to fight back when the other parent withholds visitation time from you, and I will show you exactly how to win in court. My name is Jeff Hughes, and I'm the lead attorney of Sterling Lawyers, and we are the largest family law firm in Wisconsin. We see hundreds of cases and dozens of judges every month, and that gives our clients an unfair advantage. Now, in the state of Wisconsin, when a judge enters a court order, that has the force and power of the law. And unfortunately, some parents decide they're going to completely ignore that order and they're going to withhold visitation time from the other parent. A lot of times they'll do that just to be vindictive or mean and use that child as a pawn to keep that child away from that other parent, to teach the parent a lesson, to show them who is the boss. But that is completely wrong. Now, to give you context, throughout this video, you may hear me use the word placement. That is the technical legal word for the term that most of us know as visitation. So when you hear the word visitation, the legal word, the technical word is placement. And one more thing on that, if it weren't confusing enough, the word custody in Wisconsin is the legal term for decision-making, okay? So understand that. Custody is not gonna come up much in this video. It's gonna be more about placement and visitation. Now, when there is a court order in Wisconsin setting out a placement schedule or a visitation schedule, both parents are required to follow that order. But sometimes one parent chooses not to, and they withhold that child from the other party. So what are they to do? So I'm gonna pull out the big gun first, and this is the big one. It's called a motion for contempt. This is essentially you asking the court to find the other party in contempt for violating a court order for placement and visitation. Okay, so here's how it works. Here's how you file it. Here's how you get in court, and here's how you win the case. So the first thing, this particular motion is designed when someone unilaterally on their own is violating a court order. You can't be also doing that. So understand that you have to have clean hands, meaning you have to be innocent. You have to have been following the court order. And that person, the other party, chose not to do that. So that's important. There's a secondary motion that we're going to talk about in a minute, where you could use in those instances where both parties are kind of not doing what the court order said. This is when one party's not doing it and you're the party that's being aggrieved, okay? So you go first. Number one is you get the paperwork and you file it with the court. So let me break down how you go about doing that, okay? You can get the paperwork from the courthouse in the county in which you live. You can find it online. I know you can get it at our website, sterlinglawyers.com. You can find it there, but you need to get the paperwork. And here's what the paperwork is. First, there's what's called a motion. This will be called a motion for contempt. Now, a motion is simply a request to the judge for some relief. And in this motion, you will have to lay out what you are asking the judge to do and be very clear about that, but only summarize that. You don't have to get into details here. Be very clear about what you're asking the judge to do, what remedies. Maybe it's makeup time, or maybe it's financial remedies of some sort. Okay, you're asking the judge to do something for you. And you need to indicate high level now why you're asking the court to do that. That would be you stating the other party's violating the court order. That's what you put in a motion. So a motion is simply a request to the court, and you're asking the judge to do something, and you're stating why you're asking this to be done. That's the first document, the motion. The second document is called the affidavit in support of the motion. Now, an affidavit, what is that? That is a sworn statement that you give under oath. You have to be impeccably honest whenever you complete this affidavit, because failing to do that, being dishonest, is called perjury. And that, my friends, is a crime. So this affidavit needs to be absolutely truthful that you're giving to the court. It is sworn by you under oath, and it needs to be notarized. Now, what is in this affidavit? These are the details for why the court should grant your motion. It would look like the exact times, dates, and so forth that the other party violated the court order, and be specific. Go into detail, explain what happened, when it happened. Do it chronologically so the judge can follow that, and think through how to state things very concisely and very clearly. Also, you may want to add supporting documentation to this. Now, what would that be? Well, typically, what it looks like are screenshots of text messages, or their emails, or they could be other witness statements, anything that's in documentation form that can support your case. And you want to indicate, Judge, I'm including these things, and you're going to list them, the things that you're included, the documents that you are including that will support your case. And be clear, be organized when you give these to the court, because you want the judge to read them. And if they're not organized, if they're hard to follow, the judge may just get discouraged and just not do it. So you want to make it easy on the judge to read these statements. Okay, once you get the documents filed, and they're filed with the clerk of courts and they're stamped, the clerk will likely give you a hearing date. So that's when you are to come back to court. So you'll get that date, they'll put it on there, and it'll be on the form that you need to give. It's called the summons. It'll all be on there, and the clerk will put that in when you take it into court to file it. Now you've got several copies of this. It's important to have several copies, okay? Copy for you, copy for the court, copy for the opposing party, and an extra copy just in case. So go to court with at least 4 copies of these things. When you get there, you get the court date. Now the next step is you need to serve the other party, and you have to serve the other party at least 5 business days before the hearing. So how do you do that? Well, there's really 2 primary ways to go about serving the other party. The first one is to go to your county sheriff and explain that you need to serve these documents, and they do this all the time, so they're very well equipped to help you here. They'll take the paperwork, and you'll need to tell the sheriff, give addresses and so forth where they can find the other party, and you'll give that to that sheriff, and then they'll serve them, or they'll try to at least. Now, that's one way. Another way is to find a private process server. And again, you got to pay the sheriff something. I'm not sure, it changes by county. It's not a lot, but you got to pay the sheriff some money to do that. But if you go to a private process server, they're a lot of times quicker, and they're more flexible, and they can do more for you than a sheriff will. You'll pay them a little bit more, but it's a very reliable way to get service done. Now, our firm uses private process servers almost exclusively because it's so reliable and predictable, whereas the sheriff may not be as much because they're busy. They get distracted on other things, and it may not get done timely. So you need to have the documents served by someone. Now, you could have someone who knows both of you serve the other party. That gets tricky because you have to have an affidavit of service, and some things have to be followed there. They have to give the documents, swear that they give them, be prepared to testify under oath that they gave the documents and all that. And usually a private process server is more equipped to do that. You can find these people online, really easy to find, but they're out there, and you can locate them, and they can help you do that. So 2 ways, with the sheriff, with a private process server. Now, once you get service, you have to get an affidavit of service. This is a document that says, I'm swearing under oath that I served so-and-so. Okay, that's what the private processor server will give you. That's what the sheriff will give you. File that with the court as soon as you can. Get it in the court record. Worst case scenario is you may have to show up to court and give it to the court then, but it's way better to get it in the court file way ahead of time so it's all done. So you know that that date is secured on the court's calendar. You've got your service requirements out of the way, and you're ready to rock and roll come the court date. Okay, which is the 3rd step. This is super important, as you can imagine. Now you're in court. So here's what happens when you get to court. You go to the hearing. You show up half an hour early, because a lot of times you got to go through security. Things could be delayed. You could be delayed getting there. You want to be there early. So plan to show up a half hour early. When you get there, you'll go to the court room that you're supposed to be in. You'll usually, on the outside on the wall, you'll see what's called a docket. And that is all of the court cases that are going to be called on that day. And you'll probably see your name on there. You should see your name on there. When you see your name on there, then you know you're in the right place. Go in, talk to the bailiff. Usually they'll stop you from getting any further. Talk to the bailiff, say you need to check in for court. And then they'll either take you up to the clerk, or they'll write it down themselves, and they will check you in. So it depends on the judge and how they do it. The clerk or the bailiff will be there, and that's how you check in. When you do that, just sit in the courtroom there and wait patiently for your case to be called and get ready. Now, Let me talk about getting ready. First off, when you come to court, you need to be dressed appropriately. And that doesn't mean that you need to go buy a suit, you need to wear a suit, or you need to be super fancy. What that does mean is you need to treat it professionally, like you're going to a very important job interview. So whatever you would wear to a very important job interview, wear something like that to court. Now, if you're a hat wearer, it's best that you don't show up in court with a hat on, because the bailiff will tell you to take it off, or worse, the judge will tell you to take it off. So you need to be prepared for that if it's your custom to wear a hat. But you need to be dressed professionally, like you're going to an interview. So what that at a minimum would mean a long sleeve, well cleaned shirt and pants. Don't wear, dirty jeans or something with holes in them. Wear nice clothes for court. It shows that you respect the judge, respect the court, and you want to have a good first impression on the judge, okay? That's important. Also, review your paperwork. It may be a few weeks since you filled out this paperwork. Review it carefully, read it over and over to make sure you understand everything that you said, and be prepared to answer in testimony everything that's in that affidavit and everything that is around that may not be itemized in the affidavit, but that happened. So know all of that stuff, refresh that stuff in your mind so you're ready to go. Now, in almost every case, the judge will ask you to testify first because you are the petitioner. You're the one asking for the motion for contempt. So the judge will say, okay, tell me what's going on, and they'll ask you questions. Now, if there's another attorney, that'll all change. But usually, I'm assuming you don't have an attorney and you're there by yourself. So the judge will ask you what happened, and be prepared to testify slowly. Take your time. You're probably going to be nervous. So prepare yourself to stay chronological and stay slow and reasoned in how you describe things, okay? Now, most judges by now, at this point, will have read everything in your file, meaning they will know what the original court order said. They'll have read your motion and the affidavit, any supporting documents. They'll at least have glanced through those, but they may ask you about them. And don't be surprised if you have to say the same thing that's in the affidavit, because the court is trying to create a record for what happened, okay? Now, that's when the judge will then probably question the other party and hear their point of view as to what happened. And typically, in almost every one of these cases, one of three things is going to happen here. One is the court could say, yeah, I'm going to find them in contempt. They completely had a contemptuous attitude toward my original court order, and I'm finding them in contempt of that order, and I'm going to order them held in contempt, meaning they've been ordered in contempt. That's a bad mark to have on a court record for someone. Now, there's a whole lot of remedies that the court may decide to impose at that point. Typically, they will look like some sort of financial penalty of some sort. Maybe it's to pay your costs, your fees, your attorney's fees. If you have an attorney, maybe it's your time off work to enforce that, whatever. So that's one thing. They could also order makeup time, and they could change the current order and allow you to have more time to make up for the time that has been withheld from you, okay? So they could go a lot of different directions. In the most egregious cases and extreme cases, and this probably happens only a few times in a year in Wisconsin, is they could actually throw the other party in jail if it's happened multiple times. That could happen, but it doesn't happen a lot. Don't go in there with your hopes up that that will happen. It's very, very rare. And it's usually only on the most egregious repeat offenders that are thumbing their nose at the court. Okay, that's the first thing. The second thing is the judge may do what's called a hold open, meaning I'm not going to find this party in contempt yet because I know how bad that looks, but I'm going to hold it open to see what happens and see if they follow the conditions that I'm going to lay out here in the order today, called purge conditions. That's what they're often, a lot of times called. So that's kind of a halfway point where the judge is kind of convinced but wants to see more before they issue that finding of contempt. So they're going to do something kind of halfway. That's not the greatest for you, but it's not bad. It helps. You probably get what you came for. You just don't get that big contempt finding at that point. Or third, you don't want this to happen, a finding of not in contempt, meaning the court's going to hear both sides and say, you know what, I don't believe that party violated the order. That means you failed to prove your case. If you follow what I'm saying on here, most likely you'll get one of those first two things. Okay, you'll get the finding of contempt so long as you can prove it without a shadow of a doubt and the judge can find that and you had clean hands, or you'll get kind of that halfway of holding open the contempt to make sure they follow the law, the orders of the law in the future. Any of those things could happen like that. That's more typically the outcome that you'll see. That's the big one. That's the contempt one. So I'm going to move to the second one. This is kind of a lower level request to the court, okay? So I want to explain how this is different. Whenever there's a motion for contempt, it should be clear cut that one party violated the court order and alone violated the court order, meaning that the other party didn't. They were aggrieved by the contemptuous actions of that first party. Okay, now what if, however, it's not so clear cut, meaning this happens quite often. An order is entered and the parties on their own agree, you know what, we're gonna do something different. We're gonna do it this way. And they do that for a while. And then one party decides, I'm gonna quit doing it even that way. And I'm just gonna say no visitation. And so now you've got a circumstance where both parties weren't really technically following the court order. Both parties weren't really requesting that it be found. And now they're doing something on their own. And one party's kind of run off and done something completely to violate the spirit of what the parties were following. What happens in that case? Well, you're probably not going to win on a contempt motion, so it's better not even to ask for that. But what you can and you should do at that point is say, Judge, I want to file a motion to enforce the placement orders that are in place now. And you have to go back to court to do that if the other party is not going along with it, okay? If you go to the other party and say, look, I want to go back to the original court order, and they don't want to, that's when you file this motion to enforce the placement orders. It's not as strong as contempt. It's not as risky either as you asking for a contempt motion. It could be risky for you if you ask for a contempt motion and lose, because it may show that you're just being vindictive. But when you file a motion to enforce the physical placement orders, that's you saying to the court, Judge, I now want the current order that's in place to be enforced. Okay, so how do you go about doing that? Well, it's almost identical to the first contempt one that I laid out for you. You have a motion, you have a supporting affidavit, you have service, you have all of those same things that you have with a contempt motion. The difference is, of course, you're not asking for a finding of contempt, a blatant violation of the court order. You're asking for an enforcement of the current court order you maybe want to go back to, or for whatever circumstances you deviated from, you now want to reinforce that and go back to that. That's what this particular one is used for. And like the contempt motion, you have supporting docs. So for example, if you ask the opposing party, the opposing parent, if you can go back to the order and they said no, document that. Put that in an email and say, I'm asking to go back. You've told me no. I'm now gonna have to file a motion with the court to enforce the current placement order that's in place. Now, in some cases, if it appears to the judge that you've done everything you could and the other party just wasn't going along with it, the judge may, in some cases, even give you sanctions at that point, meaning it could order the other party to pay some of your expenses if it's bad enough, right? Every case is totally different. It's hard for me to guess, but know that that option could still be there. You could ask the court to do that. Okay, now that you know how to protect your relationship with your child whenever placement is denied by going back to court with either a motion for contempt or a motion to enforce placement, I encourage you to watch this video here. 6 mistakes to avoid in your child custody case. And I'll see you over there.